Staring at my reflection in the mirror, my heart was racing and I was short of breath. Despite my federal clerkship and graduating #1 in my law school class, I was up against Baltimore's most feared plaintiff's attorney, my very first solo jury trial. And that voice in my head was relentless. You have no chance. You don't know what you're doing. That terrified young attorney eventually won that impossible case. And I discovered something then that transformed 4 decades of practice. Welcome to the Free Lawyer Podcast. I'm your host, Gary Miles. Courtroom confidence is not just about individual victories. It's the very foundation for building unshakable professional confidence that will truly elevate every aspect of your legal career. I'm Gary Miles, and after 46 years of practice, managing a firm for 30 years or so, coaching a lot of attorneys, and trying a lot of cases, I've learned that the attorney sitting across from you in that courtroom is not your biggest threat. The voice in your head is. And that voice is one that tells us we're not good enough so often. You know, we look so great from the outside, don't we? We look confident. We look like we know what we're doing. Everyone looks at us with hope and anticipation of how good we're going to be. And they believe in us, but we often don't believe in ourselves. And that self-doubt becomes our biggest opponent. It's not the judge or the jury or the other lawyer. It takes away so much from our experience. It removes opportunities that we pass on because we think we may not be good enough. We may not take on that case that might stretch our boundaries a little bit. We may not achieve partner because we don't believe in ourselves. Well, we might turn down some client because we're afraid we may not be able to handle them. And then we have that exhausting cycle of overcompensation. We work so hard to prove ourselves, working so many more hours than is really humanly possible. We prepare our cases to death. We feel like our work's never good enough. We keep reading and rereading the motion. We keep going over our openings and our closings, whatever it is. We prepare much beyond what we need to be ready to go. We say yes to everything, every client that calls us, every matter. And we end up taking on too many cases because we live in a world of scarcity where we're afraid we don't have enough. We wonder, who will we be representing 2 or 3 years from now? And it's not sustainable. It's not sustainable at all. That's why so many of us burn out. We're exhausted by our insecurity. And if we ever make a mistake, it destroys what little confidence we project. And it becomes this vicious cycle where our lack of confidence makes us prone to feel more anxiety and more stress. And that lowers our confidence further, and we feel more stress. And that all leads us to not believe in ourselves, so we don't do as good work, and we may make a mistake or may not try the case so well. Have you all ever experienced that? I know so many of us have. And generic confidence, optimism advice doesn't work for us because that ignores the unique pressures that we face. Whether it's a demanding client or a super aggressive counsel or dealing with the unpredictability of trying a case in court before a jury who was selected because they know nothing about law, medicine, the accident, or the parties. Instead, what we need are specific tools tailored to the legal profession and the legal arena. And today I'm going to chat mostly about what happens in the world of litigation, what happens in a courtroom in negotiation, and how being a confident lawyer can improve you so much. But not only that, it will help you have better results and enjoy your practice more. You know, there's a real connection between our confidence and our performance. And we all know that. Fear has a sound and so does belief. When we believe in ourselves, we're more confident. We think better. We are more decisive. We trust in our decisions and our analysis. And when we believe in ourselves, we project that to our clients, to the opposing counsel, and to the jury. And when we're confident, our brain works better. It works faster, more clearly, without hesitation. When we're in survival mode, we second guess everything. We never believe in our strategy or our thoughts or our decisions. So the compound effect is When we have confidence, we're more successful. And when we're successful, we have more confidence. And it just builds and builds. I remember the big case I tried in Baltimore County for a woman who had been fired because she complained about sexual harassment, and then they accused her wrongly of stealing a computer. And I filed a claim for defamation, and I just settled the case for $20,000. It honestly wasn't, there were no tangible damages that I could point to. And they were so aggressive. They accused her of suborning perjury and improperly trying to influence witnesses and attacked her in every way in the courtroom. And it was a bit overwhelming, but I believed in her and I believed in our case. And I actually believed in myself. And I got on such a roll because I had such self-belief, such confidence in the evidence I was presenting and how, and in my strategy, which was to be sort of humble and authentic and connect with the jury. To contrast with our angry, aggressive style, which only bolstered my argument that they were an angry, nasty company who purposely harmed my client. And the result of handling that case with that quiet confidence was I ended up getting $192,000 in compensatory damages and then $200,000 punitive damages. And kind of best of all for me and my client, the president of the company, who was the culprit, ended up being fired by the company 2 weeks later. And part of the reason I did well was because the cases I had tried, I'd learned how to develop tactics and techniques that helped me to have confidence in myself and to be focused and present. And I'll share a couple of them with you here today. The first thing to remember is that when that jury walks into the courtroom, they probably make their decision about you in the first 30 seconds. They see everything you do. They notice how you dress, how you move, what you look like, how you speak to the opposing counsel, how you speak to the court. And very quickly they make a decision. Are you someone they trust? And there's nothing you want more than to be trusted by that jury, because they will be deciding whichever side of the case you're on, your client's outcome. And how you act and behave in the courtroom makes a huge difference. Be conscious of what you're doing and how it might look to some neutral person like a member of the jury. And be particularly conscious of the fact that they make that decision about you in the very first 30 seconds or minute while they see you. I also believe how we stand in the court matters a lot. Oh, it seems like a little thing, doesn't it? How we stand? Trust me, it really matters. I call it the I belong here stance. So often we get anxious and nervous, and we don't stand up straight, and we may shift our weight from one foot to the other. All that shows a lack of confidence. Instead, plant your feet shoulder width. Feel like they're rooted in the ground. Your legs spread shoulder width apart, your weight evenly distributed, and think of yourself as a tree with deep roots. Standing up straight, relaxed, but standing up completely straight. And that will prevent that nervous swaying that screams, I'm uncomfortable, I don't know what to do. And make strategic eye contact to build trust with the members of the jury. Look at each section of the jury box. Spend 5 to 7 seconds making direct eye contact with one juror. And then move to a different section. Make eye contact for 5 or so seconds. Enough to finish the thought and shift eye contact when you move to the next thought, and keep moving from one section of the jury to another and make eye contact. And it's hard. It's hard to make eye contact. But it's a sign that you're confident and you're relaxed. And it's human. You build a connection with that jury when you do that. Same with the judge. When the judge speaks to you, look at him or her for a short period of time, and then glance at your notes, gather your thoughts, and get back to making eye contact. And it really, really makes a difference. And how you use your voice also matters. A monotone doesn't work. Yelling at the jury or in the courtroom doesn't work. But instead, modulate. Change the pitch of your voice to where you're louder and when you're quieter. And I found sometimes when my voice is the quietest, the courtroom being a pretty quiet place, but when my voice is the quietest, the softest, that's when the jury seems to listen the most. And the most important thing, particularly when you're giving your opening or your closing where you're speaking for a period of time, is to slow down. When we get nervous, we start speaking faster and faster. We want the jury to hear and understand everything we're saying. So slow down 20 to 25% from how you would normally speak in that situation and continue to make eye contact. And let's talk a little bit about how to communicate with the jury. I've seen so many lawyers stand up and they say what their name is, and I represent whatever their client's name is, and he's a whatever, and this is what we call an opening statement, etc. They go through all that before they start talking about the case. But instead, what you want to do is to start with a hook. Start with something that really grabs the jury's attention. So in my sexual harassment case, I probably said my defamation case, I probably said something like, my client spoke the truth about what happened, and the workplace was never the same after. Or something like that, something to get their attention. I try to keep it to 2 or 3 sentences, maybe 4, but I make it strong and I make it powerful. And then I move to the rest of the argument. And then you want to review the facts and connect them with your client and with your opening. And then you conclude with a strong resolution why the jury should find in your client's favor. The other thing is to remember that the jurors are not lawyers. They don't understand legal speak. So I pretend I'm talking to my grandmother. God rest her soul, what an amazing woman, both of them. And I think of them, and can I explain this in simple enough terms that my grandmother could actually understand it? And you know what also happens in court a lot is we get those curveballs. The other lawyer makes an objection that we didn't anticipate coming, and the judge sustains it and says, next question, we don't know what to do. Or the lawyer interrupts our argument to throw up some red herring, or the judge interjects to ask us a question, and we don't know what to do. And what typically many of us will do is they'll rush to say something, just to say anything to fill up the space. But instead, stop. Use the stop technique. Stop. Pause. Take a second to pause and think. Think about the situation. Think about what the possible responses are. Then organize your thoughts and then present them to the court or to the judge or whoever it might be. Stop, think, organize your thoughts and your arguments, and then present them. And it really works. And let's talk about negotiations a little bit. If you do any trial work, you're going to have mediations or other settlement conferences. And it's important to meet with your client and to discuss the pros and cons, to discuss what the other lawyer is likely to say about them, to let them know of both the strengths and the weaknesses in the case, and for yourself to reflect on these 3 key questions. What's the best outcome for my client? What's the best outcome? What's the minimum that I and the client will accept? And what happens if we walk away from the settlement conference? 3 very important questions. What's the best outcome? And what's the minimum your client will accept? And what if we walk away? And when you're there present with the claims adjuster or with the plaintiff and the other lawyer, make sure you're listening and watching, because you can read body language and learn a lot. See what the reaction of the claims adjuster is to what you have to say. See how aggressive or intimidated or what the response of the lawyer is. And when we really pay attention, we can learn so much more. And the same is true with active listening. Listen to the other lawyer carefully. Listen to the mediator. My experience with mediators is they don't lie, but they stretch the truth. And so you have to watch the words they use, because what might seem like a definitive statement might actually be hedged a little bit, because they don't want to say something that isn't accurate. And I found that when I really listen to the other lawyer, I can learn so much. So I've had a lawyer say, oh, my client could never accept that. Well, that sounds pretty definitive, but it really isn't. What's could never mean? Well, it means hey, maybe it's possible. But when they say will never, that gives a different message. And the last thing to think about is the power of being willing to walk away. I know I always felt that when I walked into a mediation or a settlement conference, I really wanted to settle, and I did. But often that created pressure on me to have to settle. We don't ever have to settle. We can try the case. So be willing to walk away and take your chances in court. And it's a sign of great confidence. So some of these are some of the techniques you can get in the courtroom. How you stand, how you speak, how you respond, how you listen. And they all work to build our confidence. And you may think, well, that's fine, Gary, but I don't do that much work in a courtroom. But what I've learned is those courtroom skills will transform your entire practice. Using those same tactics or same tools with your client, stand strong, stand with confidence, listen carefully, speak with a proper tone and pace, can really help build your relationship with your client. But that confidence you build will extend throughout your practice, with developing your practice, with speaking to the other lawyer, with getting new clients and how you interact with them, with communicating with your staff in the firm. And I really like the thought of moving from fear to curiosity. When I have a lawyer at a deposition who's super aggressive, I've seen other lawyers get super aggressive back. And they start speaking faster and talking over each other and raising their voice, and soon they look like they're almost ready to come to fisticuffs. But instead, and that all comes from a place of fear of what the lawyer's saying and doing and how it's going to impact on me and the case. And instead of acting out of fear, I like to act out of curiosity. Why is the lawyer acting like that? Why is he saying that? How will that help him? What is his strategy? What is he trying to do? What's he trying to prevent me from seeing? And when you move from curiosity, what originally was a huge obstacle, a scary challenge, now becomes a puzzle. It becomes something to figure out. And it will help you to handle that. Plus, because you're thinking through the behavior of the opposing lawyer, you're now maybe able to come up with a thought about what's really going on. And I found that when I build that confidence in the courtroom, it transforms everything else about me. I grow professionally, and beyond the courtroom, whether it's meetings with clients or networking or charging the right amount of fees, I find that the confidence I built in the courtroom extends the rest of my practice. And I know some of this isn't easy, but if you try some of these things, I think you'll really make some progress. But what are some common mistakes, some common hurdles that can prevent that progress? Well, the one is over-preparation paralysis. Sometimes when we find ourselves lapsing back into self-doubt, we will over-prepare like crazy. We will keep reading and proofreading the pleading to make sure there are no typos in it. We'll keep going over our witness examinations to make sure we didn't think of anything. We'll read that motion so many times just to find there's a comma out of place. That never serves us. Let your work go when it's good enough, when it's excellent. Don't worry about it being perfect. When you get to the point where you really aren't making many significant changes, let it go. The other is so many of us have destructive comparison patterns. We look at other lawyers and we see how we compare. How do we measure up with them? And that can really be harmful because all we do is create our own stress. Instead, focus on your own growth. How do you compare to how you were last year, the year before? The other fear or obstacle is when we ignore our physical symptoms. If you're not sleeping well, if you have an upset stomach, if your heart is racing or you're short of breath, look at those symptoms and try to figure out why, what's going on, and then come up with a solution to it. They're not symptoms to be ignored. They're not right. And I also want to say some of us try to fake it till we make it. It doesn't work for lawyers for a lot of reasons. We all deal with high stakes cases. Our matters are so important to our clients. The thought of faking it till we make it Seems strange when we deal with such an important case. And so often, that fake it till you make it comes from a place of fear and anxiety instead of belief. And when we handle our cases with a belief, we do so much better. If we're faking it, the other lawyer knows, the judges know, even our clients might know, and they need our authenticity, our leadership, our confidence. And when we're trying to act as if on the outside and the inside we're scared and we're trying to fake it till we make it, we have this conflict between the aura we're putting out in public and how we feel inside, and that creates more anxiety. So I encourage you to try to build genuine confidence. What do you need to do that? You need to prepare your case very, very well, so it's prepared excellently but not perfectly. You need to be present with your clients, present in the courtroom, completely focused on what's going on. You need to understand your strengths as a lawyer and your limitations. You need to build your expertise in your arena, get continuing education, get training classes or development classes, and use a mentor. A mentor can help you believe in yourself. Have faith, have confidence. I know when I work with my clients, they all build their self-confidence as we work together. And when I finally learned to project authentic confidence based on real preparation, my growing competence, wow, everything changed. Opposing counsel took me seriously. The judges respected my arguments, and my clients trusted my guidance. The difference between faking it and authentic confidence is the difference between performing competence and actually possessing it. In the high-stakes world of legal practice, only genuine competence will sustain you through the challenges that you face. That's why the attorneys who truly succeed don't fake it. They build it systematically and authentically, one case at a time. Here's what I want you to remember. You didn't get into this profession by accident. You earned your place through education, hard work, and your dedication to justice. These confidence-building techniques aren't about becoming someone you're not, but they're about becoming the best version of who you already are. That anxious young attorney in the Baltimore courthouse eventually transformed into someone who could enter any courtroom, feeling genuinely excited about the challenge ahead, not by eliminating nervousness, but by learning to channel that energy into focused, powerful performance. The courtroom is your arena. These high-pressure moments are your opportunities to build that unshakable confidence that will elevate every aspect of your legal career. You have the foundation. Now you have the tools. The only question is, will you use them? If you're ready to transform your relationship with practicing law, I would love to connect with you. Visit GaryMiles.net to schedule a courtesy call, or you can email me at Gary@GaryMiles.net, or you can check the link in the show notes and click on it and sign up a time that we could chat. I'd like to work with you to unlock the confident attorney you were meant to be. Thank you so much for joining me here today. I appreciate each and every one of you, and as always, please be well, be safe, and be free.